We're smiling because we're just after Law Day, Rule of Law Day, where we celebrate the rule of law and its impact in society, the role of law in society. You know who, DIna Doll, you know who isn't celebrating or didn't even acknowledge the existence of Law Day? Anyone in the Trump administration, anyone in the Department of Justice, our Attorney General, our President of the United States. They're allergic to the rule of law. They're not going to acknowledge it. They see it as a personal attack and a personal affront. And we have this episode about the United States Supreme Court and things around its ecosystem that you, DIna Doll, and I do every week here on Legal AF. We have a lot to talk about, but the animating feature or the thing that ties it all together is those that are in favor and support the rule of law as a bedrock foundation of our constitutional republic, and those that don't. That's it. It's binary. You either support and you take our constitutional republic the way it is, or you reject it and you go down the road of fascism. We've been lucky here. We've been fortunate on Legal AF because you were here from the very beginning. I was here from the very beginning. But now we've attracted, because of our audience, because of the quality of our content, some amazing new contributors. We just added, DIna, Sidney Blumenthal and Sean Wilentz. I can't think of better people. Sidney Blumenthal, award-winning journalist, historian, author, presidential advisor to the Clintons in the White House, who's now saying things like, this is Sidney Blumenthal for Legal AF, along with Sean Wilentz, who's a Princeton historian and scholar, not stuffy. I joked that these are like the Murder in the Building podcast. They're like the Steve Martin and the other guy, you know?
Yeah.
And what they do is put everything in historical context, not as lawyers, because they're not lawyers, but as historians. So they're our resident historians. They got this great gig. We call it Court of History, which sits over the United States Supreme Court, because history is going to be the judge. But they explain to you how all of the analogies that Trump's using in history are just false. And they do it in a way that's very, very engaging. So go on Court of History here on Legal AF as well. And that brings us to our episode today. We're going to talk about the oral argument about whether the last brick that separates church and state in the wall is going to be finally torn down. We have an odd situation. Only 8 justices took the bench because one had a best friend who was arguing the other side. This is about whether religious organizations can run public charter schools using our taxpayer dollars. Does that violate the Establishment Clause? Or, as Justice Kavanaugh said during the oral argument, we can't discriminate against Catholics. So the way to solve the problem and have free exercise of religion is we should just fund all religions. Well, what about people that aren't religious? Well, how does that solve for the equation? I don't understand it. Neither does Justice Sotomayor or Kagan or Ketanji Brown Jackson. We're going to talk a lot about Ketanji Brown Jackson. And you and I watched that oral argument, and a little bit of promo here. For Legal AF, we decided, the leaders of Legal AF, including DIna, that we need, as a public service for this community, to show the live streams of these oral arguments. And they're usually audio, not visual, in federal court. We've got a few more left for the Supreme Court. We've done 2 so far. One at the D.C. Court of Appeals, one at the Supreme Court. We've gotten 50,000 people to come on, watch it. 5,000 or 8,000 people watch it with us. We do commentary along the way. I was in the chat during the Oklahoma one. And this is a very odd thing. I'm going to stop talking and turn it over to DIna. This is a very odd one because of all places in the ruby red state of Oklahoma, the Oklahoma Supreme Court ruled that funding religious operated public charter schools effectively is a violation of the First Amendment and of the Establishment Clause, which says that we shall not establish any religion through the actions of the federal government. We don't get in the way of your practicing or not practicing your religion, but we're not establishing it either. And for the Oklahoma Supreme Court, it was very, very clear. Appeal got taken up to the United States Supreme Court. And after full briefing and an oral argument, one person dropped out because she happens to be best friends with a law professor at Notre Dame that she worked with that was an advisor to the St. Isidore Catholic online virtual charter school. And also the godmother, apparently, of one of Amy Coney Barrett's 8 kids. So Amy Coney Barrett, unlike Thomas and Alito and others, was like, you know what? I'm going to sit this one out, much to the chagrin of the far right, who wanted her to vote for this case. So it's 4-4. And we're going to talk about why 4-4 is okay. 5-3 sucks, but 4-4 is okay. All right. Why don't you take it from there, DIna?
Well, if you're as shocked that we are in this position, right? Let's just take a moment. We are actually talking about whether or not taxpayer money should fund religious schools. That is the question, if you have any doubt. And so let's just preface that, where the fact that we are even at that point is disturbing. And I think that the questioning from the Supreme Court, everybody that listened along probably got the same impression that the right wing of the court seems very likely to grant these charter schools, the religious charter schools request. But let's back up a little bit about kind of what the argument was, the constitutional argument. Oklahoma, in their law, the federal government in their law says that charter schools have to be sectarian, have to be non-religious, right? That is part of the law. And so the contract that basically the state enters into with the schools, again, say they have to be non-religious. And the religious school here says that clause in the contract is a violation of our free exercise of religion. As we've talked about before, the amendment, the Constitution has two provisions regarding religion. One is that the government shouldn't establish a religion. One is that it can't interfere with your free exercise of religion. And yes, those are in tension constantly. And the pro-religious movement wants the free exercise rights to be, let's say, bigger, right? Because it gives them more opportunity. So here they're saying this is a violation of our free exercise, this clause in this contract, because you're discriminating against religious schools. And the state Supreme Court of Oklahoma said, well, according to our state law, we are allowed to not fund essentially a religious school. And so the state Supreme Court struck down basically the religious schools request. And so we are in an interesting situation where the Oklahoma, not a liberal state here, was arguing in favor of not funding these religious schools. And also the Oklahoma Attorney General, I believe, who's the one that argued this, making a really good point that technically the Supreme Court isn't supposed to be the one to decide what the state law says, right? Just to back up for a second, the state Supreme Courts are considered to have the final say on what state law says. And so he really made the argument, hey, our state Supreme Court said the state law says this, and you can't step in and say otherwise. But as we know, the U.S. Supreme Court is going to step in and say otherwise. And here's the thing. Here's the kind of bottom line that the parties really argued. It is a stretch. But the religious school tried to argue that they were not a public entity, even though they would be publicly funded. Like the Oklahoma Attorney General is like, yes, our charter schools are public schools because they're free, literally funded by taxpayer money. They are open to all. They're non-discriminatory. That is how we decide if something is government or not. And the religious school said, no, it is not a government entity because it is run by a board that has private officials on the board. And because of that, this is a private entity. And so we should have the same benefit that the government gives as anybody else. And that was really like I would say the more technical argument is they were trying to argue they were private, not public. And this is why they can't get discriminated against, not so much that they are because if they're public, then the establishment clause becomes more important, right? Then it becomes obvious. The government can't establish religion. Clearly, these religious schools, they want to teach their religion. And Justice Kagan making that point, like literally, isn't this exactly what we don't want the establishment clause to do, is fund teaching of religions? And she brings up really good points of like, you may be okay with funding a Catholic school, but there are she calls them majoritarian religions and minoritarian religions, pointing out that there's much more extreme sects of religion that are not going to even want to teach basic curriculum. Are you really okay with that level of religious teaching? Isn't that where this opinion is going to go? So really great argument that it's probably going to fall on deaf ears. The one thing that I think will come up if this does indeed go in the favor of funding this school is states that don't want to fund religious schools are going to change the makeup of their boards and have their boards be filled with public officials. And evidently California is one of those states that is already like that. So even if this decision allows for public funding of religious schools, which I think it is going to do, it is going to now be incumbent on every state who doesn't want that to happen to change the makeup. And so we're going to see a big difference between blue states and red states. And one final point before I go back to you, Popok. The charter school system themselves was anti this, I think, because we now see what's going to happen. This is going to destroy charter schools in the states that don't want to fund religious schools, which, even in some red states, I don't know how many taxpayers want to fund a religion that they're not a part of. So maybe this goes back to the argument from 20, 30 years ago that people who were really pro-education, public education, were always anti-charter schools, because it's certainly biting us back for sure.
Yeah. So the thing that we're debating here, was debated during the oral argument, is the text of the First Amendment, which relates to religion, which says simply, but you see how 250 years of debate and davening over it, and everybody's got a different view. Congress shall make no law, meaning the federal government shall not make a law, respecting an establishment of religion or prohibiting the free exercise thereof. And that's the tension that's baked into the language, because they didn't leave us an owner's manual when they gave us that language, our framers, right? It was up to us. I mean, they knew what that meant in the 1780s based on their sort of slightly stilted use of language and punctuation. And now it's left to us in 2025 and the justices to go, And the tension you see is the religious right and those that ally themselves with them, Kavanaugh, Alito, Gorsuch, and Thomas, they put a heavy, it's like when you pronounce a word and you have to emphasize a certain syllable, they put the emphasis on the free exercise thereof. And those that believe in the value and the purpose of the separation of church and state, which again is a phrase that's nowhere in the Constitution, but this is where it comes out of, this concept and case law around it. Those that believe like we do, that are moderates and liberals and free thinking, and believe that if you want to have a religion, you should, but I shouldn't have to contribute to your pursuing your religion financially, emotionally, or otherwise, right? We put the emphasis on the establishment part, what we call the establishment part, establishment clause. No, that Congress shall make no law respecting an establishment of religion. And so we say things that promote a religion should not come through the public coffers, the federal funding. They say, but you can't discriminate against my free exercise. So to Kavanaugh, and the way he asks his questions, he thinks the solution is, the way we don't discriminate is we just fund all the charter schools for all of the religions. I'm like, well, how does that solve the problem? And none of the religions. Well, how does that solve the problem? I think we should not fund the charter schools, and we should focus on, we shouldn't be doing anything to establish. So you do you, religious people.
Right.
And we won't stop you from doing that, but we won't promote your gospel either, right? Through funding mechanism. And that is the tension. And that's what Sotomayor put so eloquently during the oral argument when she was asking questions of either John Sauer, the Solicitor General, or others. And she said, you want to write out of the First Amendment the Establishment Clause, and you only wanted to read effectively that about free exercise. And there's a way to reconcile it, but it's not what you're proposing. So here's what's going to happen. I'll just cut to the chase here.
Yeah.
Bottom line it. There's 4 votes to allow religious organizations to run public charter schools. There are 3 votes strongly against that. Roberts, who spoke so little during, I mean, all eyes were on Roberts because wherever he votes is going to decide this. And he said, other than introducing different justices,
Right.
Mr. Alito, Ms. Kagan. I was like, is he like the MCs, the moderator? I mean, but he did not want. Yeah, he didn't want it. Yeah, look, when you go back to a line of about 7 or 8 cases that have come out in the last 6 or 7 years in the Roberts court, he is generally in favor of religion in public life, right? And they always go down that we can't discriminate. We can't discriminate. So we got to fund, we got to fix, we got to allow prayer on the football field. We got to allow the playground, to be remodeled with public dollars. We can't discriminate because if you don't, now you're discriminating. You're making Catholic children play on a crappy playground. You're making Christians not be able to worship next to Jews. Well, there are no Jews and Muslims worshiping on the football field. So it's always this very pro-Christian sort of approach, which always scared the crap out of our founding fathers. So he's been on what I would call the wrong side of the angels in most of those church state cases, which is why I think you're coming up with, push comes to shove, he's probably going to lean right here, and it will be 5-3 to overturn Oklahoma's Supreme Court and forevermore declare that it's okay for charter schools to be run by religious organizations and take public funding. Now, if he doesn't do that, and I think there's a 40% chance or so he doesn't do that, then it becomes a 4-4 tie, which is a temporary Band-Aid. Because a 4-4 tie leaves in place the Oklahoma Supreme Court decision. So there would be no Supreme Court pronouncement to vindicate that issue. The reason I say it's a Band-Aid is because the MAGA right and Christian right will just tee up and manufacture another case which doesn't have Amy Coney Barrett's BFF on the other side. So she doesn't recuse, and they send that case up in the next term, and they finally declare, whatever it is, even if he were to go 4-4, 5-4, that. So it would be I would take the win, but it would be a temporary. So I think it's 60% chance that Roberts is going to side with the right, and they're going to say this is all okay, and just throw away that last brick between church and state, and 40% where he finds a way not to do that, and then live another day for another case where Amy Coney Barrett can actually make a decision. What do you think?
Yeah, I mean, I think you're exactly right. I mean, it's very clear that Chief Justice Roberts has taken the court's decisions in these last 10 or so years, definitely more, I guess you could say, pro-religion. So, but I do think that Justice Kagan was really speaking to him in a lot of her questions, kind of bringing out, are you really willing to fund religious schools who teach extreme curriculum or not basic curriculum at all? This is where that's going. Because we talk a lot about how the justices behind the scenes will, go back and forth in the drafts and have a lot of times to discuss. And I think that those questions were a preview of what we're going to see behind the scenes, because she's at least trying to get him to make the most limited decision that is possible, because that is where this decision will go. Your taxpayers' dollars will go to fund people who are not going to, teach the opposite of evolution or extreme views, that maybe males and females shouldn't interact. Like, that's where this is going. And I don't think Chief Justice Roberts wants that, because he is part of the pro-Christian kind of nationalist movement. And she's really was pushing back on that. So, and another thing, I always like it when the justices make little jokes in their questioning. And Justice Ketanji Brown Jackson, she had a great week. We're going to talk about that in a minute. She had a great little joke too when she was asking the religious charter school attorney. She said, "So I'm trying to understand your establishment clause, see nothing to see here position," which I thought that was funny, because that was their thing. Nothing to see here. Like,
write it out. Write it out. Just take an eraser. Just take a white out and white out the parts of the Constitution you don't like. I mean, I always joke that if I ever got a chance to look at the pocket version of the Constitution that Donald Trump and MAGA carry around in their
Right.
pocket, it only has 2 sections: Article 2, the power of the president, and the Second Amendment on gun
Yeah.
rights. Everything
Right.
else is like, I'm like, where's the rest? Oh, that's all we care about.
So true.
And that's all we emphasize.
Yeah.
Listen, I am the way the framers did the Constitution. It is not rank ordered. The numbers don't, it's not that the First Amendment is over the Second Amendment, and the second, it's not ranked. Okay, these are all equal in their import, in their sphere of what their subject matter. And then the same thing on the articles. It's not like Article 1 of the of Congress is greater than Article 2 because it's a number higher than, and the 3 is the judges. No, it's all 3 are co-equal. Everything is equal. Every word that's used in the Constitution has equal import and power if you do it right, but not to Mac. And the weirdest thing is, and we just want to call out their bullshit, is that the ones that write out and edit out and white out whole sentences and clauses and punctuation from the Constitution are the ones that falsely claim that they are originalists, that they are textualists, that we are just here, and that's a lie. Because what you see is they don't like every word. And even though in a contract or in a statute, they'll take extra pains to say, oh, you have to read it in a way that gives merit and effect to every word, except when we get to the effing Constitution. And then it becomes, well, I don't like the way that phrase reads. I'm going to focus on this phrase. Yeah. Really?
Absolutely. I mean, they are activist judges. The Second Amendment clearly talks about a militia. And if it wasn't for the Heller decision, Justice Scalia wrote back, I think in 2008, or I might be having that a little bit off on the year, that we would not have a personal right to bear arms. They are clearly willing to, this whole idea of it's in the text is kind of a joke. And it's not true. Otherwise, the Second Amendment wouldn't be interpreted as it is right now.
Yeah.
And never mind reading the Constitution. I mean, total side note, but I don't think you saw Trump not even understanding what the Declaration of Independence meant. So I think you're almost giving them too much credit that they've even read all the other articles and clauses of the Constitution. Unfortunately, I think they probably only care about the second. Maybe that might be the only one they read. So anyway, so we will, I like your optimism, Popok. We're not optimistic very often. I like your optimism with Chief Justice Roberts. And if not, the stopgap will be a state by state situation. The states that care, and maybe even Oklahoma might rewrite it to require the boards to have public officials. And, so we'll see how that goes.
Yeah, agreed. And let's move on then to the latest emergency petition, number 12, if you're playing the Donald Trump craps all over the Constitution home game. And the reason we have 12 emergency petitions by Donald Trump is, as we talked about at length before, this is his way to short circuit the deliberative process of the Supreme Court. That is a body that generally does not operate well under pressure, does not operate well under emergency situations, is built to be a tortoise, not a hare, is built to be deliberative, and with lots of briefing and lots of time behind the scenes to lobby each other in a very collegial way to get votes and to circulate decisions and opinions and have the law clerks go to lunch and pizza parties and whatever, and then a little time in the hallway with Amy Coney Barrett and Ketanji Brown Jackson, a little, hey, do you want to go to Sweet Greens and whatever with our federal marshals in tow? Do you want? But Donald Trump doesn't want all that. He wants to eliminate all of that and just make this knee-jerk ideological voting. So the way to do that is you conjure up phony emergencies. I mean, the animating policy of the Trump administration is every effing thing's an emergency. Venezuela's at war with us. It's an emergency. Oh, I get to use the Alien Enemies Act if it's an emergency or a war. Everything's an emergency. And so, he tries to expand his power by claiming false emergencies. Now, the Supreme Court has been complicit in all of this because on one side, they want to eliminate the criticism they got for operating a shadow docket, right? which is you file an emergency petition, they vote yes or no on bringing it on board very, very quickly with very limited briefing. Then the first justice that gets it doesn't want to look like they're doing things in the dark. So she or he refers it over to the full 9, even though they have the power to reject it as on an emergency application. So now they've converted it from an emergency application that one justice can handle into a whole full-blown thing without proper briefing, with an incomplete skeletal record, without any time for deliberative process, without any oral argument. And they issue like these 1-paragraph, what do you call it? A magic 8-ball meets an oracle. Like, what are they talking about? How do you, instead of the 5, 6, 7 months of process and briefing and oral argument, and then more, or maybe even more briefing, and then they think about it, and then they cogitate about it, and then they work the hallways about it, and then they make a ruling, and then it's 40, 50, 60 pages, and you and I spend weeks trying to figure out what that means. So Trump figured out that if he short-circuited the Supreme Court, it would be to his advantage. He'd get instant voting, 4-3, and then he'd only have to fight for the middle with Roberts and Barrett. So we have the latest. And this one is about the temporary protective status of about 300,000 Venezuelans, but you could insert another group. You could insert Haitians, you could insert Colombians, you could insert Nigerians, whatever you want to insert there. Happens to be now about Venezuelans. A federal judge in San Francisco, Judge Chen, took a look at the decision by Kristi Noem 14 days into her office and said, no, you can't overturn the prior secretary's ruling to give these people 18 more months to stay in the United States. And, but that's inconsistent with the argument that Trump's making, right? That on one hand, we got to get rid of these Venezuelan scum, his words, not mine, and get them off the street because they're all members of Tren de Aragua, which is totally false and slanderous against that group, and blood libel against that group of people, very proud group of people. On one hand, you have to say that, but then think about this, DIna. In the other cases about the Alien Enemies Act, they say that Venezuela is so bad of a place that a narco-terrorist gang has taken over leadership and runs the country as a narco state. Well, then how does that square with Kristi Noem announcing that everything is safe in Venezuela for people to return to and they don't have to go back? How do you square that circle? Go ahead, I'll turn it over to you.
Yeah, I mean, and that's what were arguing in their petition that they filed with the Supreme Court was, one, they're not following the procedure. Of course, Trump is not following the correct procedure, and that this is racially motivated. They're calling out Trump for doing that because even the example, as you were saying, I mean, Ukraine, we have so many migrants who legally came here during the Ukrainian war. We're not hearing about Trump wanting to deport them because he likes the color of their skin. I mean, there is a real targeting of brown and black people in this country by Trump. And this is not people are here illegally. Let's make this really clear. When Trump was saying, the border crossing is a problem, the criminals are a problem, people, they have legal status. They have temporary protected status. It's temporary, but it's legal. And it's because the government gave it to them saying that it is too dangerous for them to return to their country. And to your point, Trump is making the opposite argument depending on the case. And so the Venezuelans are asking for the stay to remain in place, basically for them not to be deported while the underlying issue of whether or not they should keep their status remains the same. The Supreme Court, they have seen what happens, the planes, people can't come back. This should be an easy decision to stop the administration from deporting anybody until the actual case is decided. Because that's all this is. This isn't, again, asking the Supreme Court to decide the case. This is asking the Supreme Court whether or not to stop Trump from deporting them while the case unfolds.
That's right. That's what people sometimes forget. That's why these emergency wins, and Donald Trump's had a handful of them, although he's on the losing end of most of them these days. These emergency wins are not about the substance of the case. And the Supreme Court has yet to rule on the substance of any Trump policy as of today. It's all about procedural issues. And yes, if they stop or stay, you may think this indicates that where the votes are, but not necessarily. When we come back to the next term, we're going to start seeing the Supreme Court really making a decision about where they stand against the lawless president. But as of right now, they haven't. And he's been on the losing end of the last two decisions, 7-2 and 9-0, about immigration. So, it's interesting that he's pressing his luck, Trump, to try to take on another immigration issue with the ringing in his ears of the last two losses, trying to reverse course and get a win. It's very interesting. If I were them, I would just let these poor Venezuelans, poor in terms of I have pathos for them, stay in the country. As Judge Chen found, they are higher educated and commit less crime than the average American. And they've contributed billions to the economy. And I have friends in the Venezuelan community here in Miami. And this is my little note to them. If those aren't your brothers and sisters and aunts and uncles and cousins, it could well be those that are Venezuelan citizens and that vote. So you should see your face in their faces the way that I do. And how you can continue to support Donald Trump with his depraved immigration policies is really beyond me. And I'm talking to you, the Venezuelan community, the proud Venezuelan community that sits in Miami, in and around Doral Golf Course, and in Doral, and around Donald Trump International, and all of that. This could easily be you. Is it okay for the President of the United States and the Homeland Security Director or Secretary to call your people scum? And to equate everybody from your country with being part of a narco-terrorist gang? I say no. And I say no. And that should be something that motivates people come the midterm elections, if not beyond. Let's talk about.
And they did it the right way. They did it the right way. There's none of that argument of I came in legally, they should too, or whatever. These people have legal status. Yeah.
They're documented. Right. That's what this is. To end it on this is a program that was bipartisanly created in 1990 by George Herbert Walker Bush, Bush the Elder. It's a Republican idea to do this. And it's supposed to protect people whose countries are war-torn, hit by natural disasters or national emergencies, or, for other reasons. And Venezuelans and Haitians and all fit that bill, Cubans and the rest. So that's where we are. Why don't we switch gears to end the podcast on unprecedented and talk about standing ovations?
Okay,
we can bookend them. Earlier in the week, we had the longest-serving Deputy Solicitor General in America, who decided after 46 years that he couldn't do it any longer under the Trump administration. He's not retiring because he wants to. He's retiring because he just can't. He can't support representing the United States of America under a Pam Bondi, Donald Trump, Todd Blanche dystopian vision of what he's supposed to do, and working under John Sauer as well. And so after his 160th oral argument, he's right 100.
Yeah, it's impressive.
And it set a record. So at the end of it, and this guy is, I'll give you his name in a second. He's a very, very mild-mannered guy. He's known as he's sort of the living embodiment of everything that's right about the rule of law. Apolitical, professional, integrity, professionalism, candor, duty to the tribunal, the whole, candor to the tribunal, the whole thing. And Edwin Kneedler, at the end of his 160th oral argument, left the podium, and Chief Justice Roberts, with all 9 on the bench, called all the advocates back, and he said to Kneedler, Mr. Kneedler, this was your 160th oral argument before this court. That is a record. People were very amazed. And he said, I'm paraphrasing, you represent everything that's good and right about our profession. Now he's talking to Trump.
Yeah.
You represent the rule of law. You represent integrity and candor and professionalism and ethics. And we can trust you and rely on you. And we did all this time. I understand this is that you've decided to resign. That's what he said. Yeah. And before you do, we just wanted, we wanted to compliment you and tell you how much you've meant to this court. And then the audience and the Supreme Court justices, all 9 of them, and I've never heard this before, the Supreme Court justices led a standing ovation with smiles on their face. It wasn't like forced.
Yeah.
All of them. It was a rare moment of bipartisan, collegiality displayed in public by all 9 of them. You saw what their faces looked like during State of the Union addresses and joint.
Right.
They all look like they just got a bad, a bad report card or something, or their kid did or whatever. So you got that. And then that's the first standing ovation. But you talk about the one that just happened with Ketanji Brown Jackson, who and why we're bookending and closing our episode with standing ovations and why they matter.
Well, she did a speech on May 1st, Law Day. And this is something that has usually gone quietly, as you talked about kind of in the beginning of the show. But she gave a speech very pointed, clearly about Trump and against, what he is doing against the rule of law. And she gets a standing ovation as well. Some of the things that she said, she said, across the nation, judges are facing increased threats, not only of physical violence, but also professional retaliation just for doing our jobs. And the attacks are not random. They seem designed to intimidate those of us who serve in this critical capacity. Things that we are all seeing in real time, but for a Supreme Court justice to stand up and say it, again, calling it out. We saw Chief Justice Roberts do that, but her giving this entire speech and getting a standing ovation there from all that were in attendance, showing that, before Trump even took his oath, there was some columnist who said, you have to hug a lawyer because lawyers are going to be on the front line here. And we have seen the jobs that we do are usually kind of behind the scenes and boring. But the lawyers, the justice system is the one check right now against Trump, in particular, the Supreme Court, who, yes, we may not like how their opinions are with religious schools or et cetera, but they are going to stand up for the law because they are the ultimate authority of the law in this country. And so, yes, it was great to see her speaking out and getting the standing ovation. And I think the Supreme Court, the more that Trump talks, the more that J.D. Vance talks, the less they're going to want to give him all that authority he wants.
Yeah, I agree with that. There's a great article and piece in the Associated Press. Shout out to the Associated Press for standing up against Donald Trump, in which they just said the Department of Justice is no longer trusted by any federal judge. I mean, we've had cases, just one after another simultaneously around the country, and then during the week, where the Trump administration's lawyers are just slammed by federal judges for being ill prepared, not prepared, purposely in the dark, misleading the court, violating court orders. One after another. Donald Trump and his Department of Justice aren't losing 90% of their cases and have over 130 injunctions of some form against them because of leftist, Marxist, activist judges. They're losing because they're proposing ridiculous, meritless arguments that are not based on the law and the facts, with ill-prepared, not talented, not accomplished lawyers that are now left in the Department of Justice because the entire varsity squad has left. This would be like a major football program in college where like all 65 varsity athletes went into the portal for transfer, and the only thing left was like the water guy, the water boy, the towel guy, right? The one that did the lines on the field, and they're now arguing frontline, law in a federal courtroom up to appellate court. This is what we're watching. Everybody that's anybody has left the Department of Justice. The only ones that are left are the ones that are either MAGA in their heart or just feel like they got nowhere else to go. They didn't have time to go find another job. Things changed so quickly. They got caught flat-footed. And that's why he's losing, over and over again, even though he blames other things. So for Ketanji Brown Jackson to say, listen, I'm here and she's all lawyers, all judges. This was the First Circuit Conference, which is one of the 13 circuits of the federal court. It's Maine, Puerto Rico, and Massachusetts. I think so. That's the appellate court, and she was invited there. But this is during term, as you and I joked before we recorded. This is not after hours. This is this is not during summer. This is like she's in session, when she gave this thing. And she said, I'm going to address the elephant in the room, but she never named him. But we knew who the elephant was.
Yeah.
And she wasn't talking about
sure.
the Republican Party, you know? And she said,
Yeah.
judges are under attack, and it undermines our democracy and our constitutional republic. And what we're watching now is not things that are consistent or are aligned with our values as an American society. And judges should not be attacked or have their livelihood threatened just because they're doing their day job. And she said, I'm going to take a point of personal privilege on May 1st, which is Law Day, and I'm going to defend the judges and the attacks on the judges. And we need to stand up as a society, as a group. And she broke ranks. She broke her silence. You know, when I say she broke her silence, she's not like Clarence Thomas, who didn't ask a question for the first 15 years on the bench. In fact, I've been very impressed that I think it was her second oral argument. She led the questioning, which is unusual. Usually it takes 3 to 5 years for a Supreme Court justice to be comfortable. She was comfortable for day one. You can put this in a time machine or in a time capsule. When, not if, the Democrats retake the White House, Ketanji Brown Jackson will be your and my Chief Justice of the United States. I have no doubt about that. We will have Hakeem Jeffries as Speaker of the House. We will have which will be a great thing to happen after the Trump era. And Ketanji Brown Jackson, if she's not the brightest on that panel, she is one of the brightest. She carries such intellectual heft and gravitas with her. She is so insightful in the way that she conducts herself during oral arguments. I can't imagine what she's doing behind the scenes in chambers. And with her colleagues in terms of using her great intellectual gifts to try to convince people about her position. She gets so to the point, so
really
during oral argument that it's almost shocking, even as an advocate like me. It is shocking to see how quickly she gets surgically to the heart of the matter with one question in a way that even the advocates are like, they weren't even anticipating it.
Right.
She said, why don't you tell me, I love when she says a version of, let me give you what troubles me, and then you tell me why I'm wrong. Now, whenever I hear that setup, I know that person has been walked into a trap, a bear trap. They just don't realize it yet. It's snapped around their leg and has hit their femoral artery, but they don't know it yet. They're bleeding out at the Supreme Court because of Ketanji Brown Jackson. She is a gift to behold. And when she steps out, after Donald Trump bashed her on the campaign trail, oh, lunatic liberal justice they've nominated who won't even say what a woman is. Oh, you know, just crazy radical Ketanji Brown Jackson. You know what? He's going to be the bane of his existence. Even on the losing end, you will find, I'm sure, in that big court of history, to paraphrase Sidney Blumenthal and Sean Wilentz here now on the channel, when we look back on it, the power of her dissents, and Sotomayor as well, too, is going to be recognized by history more so than these ridiculous majority opinions. And they're going to say she was right.
Yeah.
And she was on the right side of the angels and the right side of the bend of history in her decision making, right?
Absolutely. And for those people who are now going to be listening along because you have your live going and you have the little picture of who's talking, listen to her question, because her question is usually what the whole decision is going to turn on. Like her questioning during the Colorado case of whether or not Trump should be on the ballot, her questioning was exactly what the 9-0 decision was held on. She tends to get straight, like you said, straight to exactly the legal pivot on it. So for me watching it and for everybody else watching it, I find her questionings to be like the most enlightening, because she tends to get right to that point. I mean, everybody else makes great points, but she gets right to the pivot that they're going to decide on.
So that's a good promo for the channel, because if you go up right now under the playlist for live, you'll see this week's Oklahoma church state case, and it's an hour and a half. It's up there now. We rigged it with the production team to be able to throw up a photo so you'll know who's talking. Just scan through, look for Ketanji Brown Jackson and stop and listen. Yeah. And that's a masterclass, even for a non-lawyer, on how a justice should conduct themselves. And if you want to know, how can you tell if a justice or a judge is really smart, really insightful, and has the makings of a Chief Justice, listen to Ketanji Brown Jackson, and you'll see. Everybody will see the difference. So we've reached the end of another episode of Unprecedented. We do it once a week for a reason. Usually we take a little bit of a summer break because the court takes a summer break, but because of all the emergency applications, as we've described, there will be no break. Sorry, DIna. There'll be no break this summer. I won't have to hear what you did on your summer vacation because I will know every week on Unprecedented right here, and everybody, so you can count on that. Usually the summers, remember last summer it was like, we'll do like a update of the cases that are coming in October, and no, forget it.
Many, right?
There's going to be an emergency application every week here that they're going to have to be pulled together for, that you and I are going to have to talk about. We may not see an oral argument again until once this last batch is over, until October or November, but we could have something momentous. They have done oral arguments before. We're glad you're here on Legal AF. We are growing leaps and bounds. We crossed the 600,000. We're at 610. I wouldn't be shocked if we're at 620,000 subscribers here on Legal AF YouTube by the end of this weekend. We're well on our way to getting to 1 million. And why does it matter? Because it's the juice I need. It's the gasoline that I need to continue to grow the channel, the subscriber base, to bring on new and talented people. We just added Cindy Blumenthal and Sean Walentz. We're about to add next month another amazing group with their podcast at the intersection of law and politics for an entirely different view. One person was in the FBI. The other one was a Yale law professor. They bring a whole other perspective as well. All right here. And then if you can't get your fill of Legal AF, and who can? I can't. We created a Substack, which a lot of our contributors are going to be contributing to, including me, called Legal AF. That's easy. Go on Substack. It's a great place. Midas is there. We're there. And I'm posting content 4 or 5 times a day. I started off with a morning AF. What else? Sort of my view of where we were yesterday and where we're going tomorrow at the intersection of law and politics. And then we post court opinions, court cases. When people say, I'd like to read that myself, it's there. Live, ad-free versions of the podcast, all on Legal AF, the Substack. So take a look over there as well. DIna, look forward to you're doing some amazing new work with Melba Pearson, another contributor here who worked formerly in the American Civil Liberties Union. You guys just put up your first hot take together, which I was like, okay, let's go. Let's go. Let's do that once a week or twice a week. So you're going to be doing that regularly with Melba. Yeah. And then, of course, regular commentary that you do on the Midas Touch Network and here on Legal AF. So until our next All Things Unprecedented in Legal AF, it's DIna Dahl and Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.